Welcome to our CompTIA, Association of Information Technology meeting tonight. My name is Cherokee Boos, and I will be introducing our topic or our presenters. But first, I have a quick announcement for our from a member within our organization. And there's going to be a meeting, conference called Critical Infrastructure Protection and Resilience Americas Conference that's being hosted Tuesday, May 7th through Thursday, May 9th at the Doubletree Hotel, the Tampa Airport off West Shore. And tonight I'm really excited. I'm pleased to announce we have some really great presenters. Tonight we have Richard C. Markow and Tom McThenia Jr. of Gray Robinson Attorneys at Law. And we have a really great presentation. They have a really great presentation planned for you tonight. I'm sure you guys would do a better job introducing yourselves than I could, but I'm going to go ahead and hand that off to you. And thank you guys so much for being here tonight.
Thank you very much. We're glad to be here. Let me give you a little quick background. Gray Robinson, we're a law firm of about 300 attorneys in 14 cities around Florida. So we are sort of everywhere you would think of in Florida except the Panhandle. Not on purpose, just historically stretched from Miami to Jacksonville on one coast, Naples to Tampa, and then I-4, Gainesville, Tallahassee. We have a number of attorneys that practice in the technology field, in the intellectual property field, and in corporate and other aspects that I think are relevant to your topic. And by way of introduction, I've been practicing law related to technology and IT since law school. I was fortunate to work in Washington and during law school and updated a talk on software patents in about 1989. And in those days, the only software patents you could really get were ones that made a physical impact. For example, using software to cure rubber. I then went to practice in the Research Triangle as a young lawyer. We represented a lot of clients that were building the backbone of the internet, did a lot of patent and other technology work there. And then I spent much of the 90s at the Coca-Cola Company. I worked on a global enterprise system implementation and spent a few years as the lawyer for the chief information officer. And while there, I learned an awful lot of things I never thought I would. For example, one day the general counsel came in and said, there's this thing, it was about 1996, I think. There's this thing called the EU Data Directive. We need to figure it out for Coca-Cola. So I'm happy to be here to talk to you. I spent the .com years in Virginia representing internet companies and investors, people that got started, did well, IPO'd, and went bankrupt, the whole gamut that maybe some of you in the IT world experienced in those years. So I'm glad to be here tonight. Our topic is 2019 Cybersecurity Law Update, Legal Requirements and Considerations. And before I let Rich introduce himself, I'm involved with the ABA Cyber Law Committee. I've been involved about 10 years. And what I will tell you, in the last 6 or 7 years ago, cybersecurity wasn't really on the agenda. And the last few years, cybersecurity is the dominant issue that everyone is trying to figure out. What is the law? What are the legal requirements? So we hope to share some of that. And we hope to talk a little bit about things that IT professionals might be more involved in that they 25 years ago weren't as involved in. Rich, why don't you?
Sure. My name is Rich Markow. I'm also with Gray Robinson. I'm their newest associate. So I went to law school after a career in IT. I was a technology consultant at Computer Sciences Corp. So I helped a lot of Fortune 500 and startups implement new and disruptive technologies and disruptive business models. And I see what's going on in cybersecurity and data as another disruption, that it's becoming intellectual property. It's not just systems, it's the way you do business and it's the way you make money as a company. And for a large part, it's how the company's valued. So as we go through it, we're looking at legal requirements and considerations of the data as it's acquired, as it moves through your organization, and then interconnects with other organizations, because all those come back to, could haunt you or could add value to the business. And then we're looking at the role of the IT professional in various commercial transactions, including due diligence for acquisitions or for partnerships or contracts and M&A. And what everybody wants to know, the reasonableness standard. What is it? And how do you protect yourself? And then we'll have some questions and answers. So we'll start with the legal requirements. So basically, the legal requirements for personally identifiable information differ by industry, by state, by the type of data you have, and the how the data is being used. So you have to be very careful to make sure you understand all the different buckets you fall into. And as you move that data through your organization and either add to the data or basically transform it, you may have different requirements.
One thing about that slide that I think is important is the first part we're going to talk about is the U.S. and for those of you that may practice in a global organization, the United States has decided up to date to treat regulation of data differently than many other parts of the world. We tend to look at it by industry, and we tend to focus it as a consumer protection issue. If you remember, I mentioned my crash course in the EU data directive in the mid-90s. The European data regime, the prior one and the current GDPR regime, focus on data as and privacy of a person's data as more of a human right. Canada's somewhat in the middle, but a little more in the Europeans. You've got the Koreans have had, and a number of other folks have regulations. So we're going to first talk about what the U.S. industry is very quickly. And for those of you, as you maybe look and see what industry you're in, if you're working in healthcare, there's some specific things. If you're in financial industry, there's other things. But just realize that if your organization touches, maybe with an outbound website, touches and interacts with Europe or European citizens, there's now things to know if you have Canadian customers or operations. And so this has become an area where I see in IT professionals increasingly being more and more central. I know one of the questions I had to ask in the mid-90s is, well, where is the Coca-Cola company's data, and where is the bottling system, which was not part of the company, mostly were independent owned, but where was it? Meaning, where are the servers, where does the data flow? And that was a new experience, certainly for lawyers. I don't know that it was new for IT professionals, but the legal regime was going to look at where the data flowed. So for example, in those days, if a server was outside of the EU, the problem was the Americans, we were considered not to have adequate protection, if you remember those days. So the initial draft wouldn't allow you to send data, for example, from one company, European operations to the US. It was a real problem. So IT professionals, I think, got more integrally involved in the compliance by just simply things like where do we store the data and where do we run it. But these first sections are more US focused, and then I'll talk a little bit internationally when we get there.
And I'm just going to touch on them just so you're kind of aware of the different standards, because each one of these could be a discussion of its in and of itself. But if you look at healthcare delivery organizations, so basically your doctors, your hospitals, they have physical standards for best practices to be introduced to manage protection of the physical environment. And you have to protect from fire, because if it's someone's medical record, you have to preserve it. Then you have environmental hazards. Again, if like 9/11 or something where the building or the area gets destroyed. But then intrusion. And intrusion they define as both physical and online hacking. The technical standards are securely communicating healthcare and user authentication. So you can't just send it. You have to have some sort of authentication process. And then administrative safeguards, they require active monitoring so that if you see something or a breach occurring, you can stop it, or abnormal activity, you can flag it. And then conducting risk assessments. It's not good enough to just say, well, we have the latest and greatest standards, we've got the latest software. You actually have to physically test and do assessments of your security.
And this area in the healthcare is one that I think in the United States is probably maybe closest or more similar to some of the European concepts, in that we really our regulations are seeking to very much protect the individual's personal health data, because we all consider that to be important to each other, right? I mean, I'm a little more concerned sometimes about maybe what my health is than what I bought yesterday on Amazon, right? And so so that's a little bit closer. You'll see it's much more detailed, the regulation. All of us have the experience of every time we want to go to a healthcare provider, I feel like I signed the same HIPAA release 73 times, right? And some of that is just the regulation, and some of it, as maybe if you're in the healthcare industry, you've seen the whole medical records industry being mandated and taking off, and having, I think, the user experience seems to always be one of the challenges of large implementation. I was at a doctor's appointment recently, and the doctor was for an elder patient, and the doctor had a person sitting in the room whose whole job was to enter data into the medical records. And I thought, well, that's actually a good idea, because it freed the doctor up to interact with the patient instead of having to enter data. And I know that's a complaint. So this is an area that we wanted to show you is probably one of the most strictly regulated in the U.S. And it's, I think, because there's a lot of common agreement that people's medical information is a good thing to protect.
But you also notice the introduction of fuzzy standards. There's a risk of compromise. You have to sort of address that and have a plan and have thought through the risk of compromise and when it in being accessed and transmitted. So your policy has to cover that. Medical devices, the FDA will not approve or bless your standards or security. They leave it up to you. And so, quality system regulations are on the device manufacturer. Healthcare delivery organizations are responsible for implementing it according to the device manufacturer standards, as well as all the updates are in place. But both are responsible for putting in appropriate mitigations to prevent hacking and ensure safety. So again, this is where you start to say, well, you're responsible now for what the device manufacturer does, and the device manufacturer is responsible for what the hospital or the end user does. So you start to see this. You got to start auditing not just your own internal standards. You got to start going outside your organization to everybody you interact with.
And I think this is an area that's moving quickly. If you hear a lot of people talking about the Internet of Things, and I think there's a new term I've just seen flying around about a medical device as a software. So as people are using wearable health monitoring, health things, all of that, where does that information go? Who can use it for what? What consents do you have are rising issues. And I think you'll see this regulation is, I think, becoming more essential to have you as the IT professionals involved, because very few lawyers are going to understand much of any of this, and I'm not sure the people necessarily writing the regulation understand the practical reality. How do you have a whole bunch of patients that you're at home monitoring their blood pressure, and that information is going from their probably not terribly secure home router back over to the hospital? Whose responsibility it is that, and what do you do with all that data? So I think this is an area that's moving very quickly. You see the guidance is 2018. This area of the law is moving quickly, trying to keep up with the professional growth.
And there is currently a 2019 standard that's out there that hasn't been approved and promulgated yet, so they're still working on it. And again, financial services has a whole different set of standards. Payment services directives. The key thing, 2 or more authentication tools, so you can't just have one method. Transaction risk analysis, so you got to monitor transactions, and if something is out of the norm, you have to flag it immediately. Authentication code dynamically linked to a payee and the amount. So when you send the amount, they can't change who it's going to, or they can't change the amount electronically en route. So you have to have connected. And then mobile security, including countermeasures. So again, somebody tries to hack, you have to be prepared and be able to stop it. And then, payment card industry data security standards, another standard for non-console access and remote network access. So if you're logging into a system, to a network remotely, you have another set of standards.
And that's an area, the financial is more, the regulation is more mature, but what I'm seeing, for example, at the ABA Cyber Law Committee, which are the lawyers trying to get ahead of all this, is there's a lot of talk about some holy grails of authentication. How do you really do that well? And then blockchain, which we're not going to talk about, but that's, other than to mention, that's a lot of people have put some real sort of hope that the blockchain technology can improve authentication of financial transactions. How that plays out is to be seen, but there's a lot of emphasis and energy being put in that, both technically and then legally, to figure out what does that mean. For example, title records, there's proposals to have house title records all handled in blockchain, which would be very different than going down to the local county and thumbing through the paper that's been there for hundreds of years.
Again, Fair Credit Reporting Act, determining creditworthiness, insurance eligibility, more and more things. I was surprised coming here to Gainesville. The rental security and background checks is so different than what I'm used to up in from Boston. And all that's governed, but what they can do, how much they can charge, how they score your application.
And these are a lot of the consumer protection ones. We talked about how in America we started with protecting data as a consumer protection concept, and this is where a lot of these would be grouped. All of these are moving quickly. What we see in many areas of the law, you don't see regulation and guidance on a yearly basis. You see it on a decade or multiple decade. We're seeing, all of this has grown up since I began practicing law. I tell people, like my students, when I teach at the university, that the internet happened, right? I was a lawyer before the internet happened. So many of you may remember fax machines, pre-email, all of that. So this law has also developed in the same 25, 30-year period, and it's moving very quickly. And it's impacting day-to-day operations more and more as we get down to levels of what security do you have to process people's credit cards, for example.
And again, you'll see the last tenet, reasonable. You have to maintain reasonable security. I know all you guys know what that is and can put your finger on it and give it an exact answer, right? Which there is none. So it's just basically it's evolving, and you have to evolve with your industry and with your peers. Consumer, again, this one is interesting because this defines reasonable. They define it by who they go after for being unreasonable. So no written information in their security policy, no reasonable access controls, inadequate training of employees, no knowledgeable knowledge as to whether third-party providers were using reasonable methods. So that's sort of how this evolves. It's by default that what the FTC figures out is unreasonable.
And so this area, a lot of emphasis is on cybersecurity. I think we share this to say in the late 90s, the FTC was spending a lot of time, if you remember, does anyone remember the late 90s, the advertisements of you would get $400 off of a computer if you signed up for AOL for X months. Or, there was tying of the purchase, a discount of the computer to some sort of internet program. The FTC spent huge amounts of time in those days on enforcement. I represented a few internet retailers that were under FTC scrutiny. The FTC isn't, that has matured. Now they're into, well, what is it that you're doing? And as you look at this, much of this is going to involve the IT professionals. This isn't lawyers sitting somewhere saying, I wonder if the contract is well. This is practical requirements on how a business is acting and protecting information.
Yeah.
Okay, so this is what we were saying. In the United States, we have this quilt, and so there's different states have different laws. We really just wanted to let you know California seems to be trying, has implemented several state policies both on privacy, the internet. So California is essentially, as a state, legislating things that impact some nationally, because if you do business in California, you're impacted, and if you have an internet website, then you're in California, right? So they seem to be taking the state lead, but this shows the quilt. Let's go on to the next.
Sure.
And then there are some specific protections. The child and minors is old. There are specific groups of people we've decided to protect with use of their data or involvement. Some of this goes back to the internet, early internet. Some of it is more cybersecurity. Let's go on.
Yeah, and then just quickly, based on how the data is used, so credit card numbers, sharing with third parties, aggregating internal and external data, you have different standards that evolve.
And this is what I mentioned at the beginning. Internationally, more countries have comprehensive legislation that is both on protection of data, but also moving over into cybersecurity in the sense that it will cover, things that happen to the data, such as breach notification. The Europeans more recently enacted is the broadest. There's discussion in legal circles, which may not be as interest of your group, but it's really this concept that they've forced their law on the whole world because they require, if an EU citizen is impacted by a website, this sort of comes across the pond here. So a lot of companies are trying to figure out, well, what do I have to do to comply with this new European law, even if I don't really have European operations? And here in Florida, where we are, there's an awful lot of visitors from Europe, and so the hospitality, for example, industry has to really look at that closely.
But I was going to say, we mentioned Florida. Florida has a reasonable measure standard.
So the next topic we want to look at is what I've been involved in a lot of commercial transactions, mergers and acquisitions in the technology space. So I told you I originally went to Coca-Cola Company for their global implementation of an enterprise system. They were trying to implement it both in the company and in the bottling system they didn't own. So that involved going around the world and saying, why don't you Philippine bottlers spend X millions of dollars to put this system in? And as you would understand better than me, I learned a lot both about the law, but I learned a lot about the reality of IT implementation. The resistance of, well, that's not how we've done purchase orders. I don't want to change. And so if you fast forward, I think what I've seen, our general premise is that IT professionals are becoming both more involved and more essential in commercial transactions, in part because of the cybersecurity risks. So we're going to walk through a few case studies of companies you probably have heard of who've had unfortunate experiences in the process. And we're going to kind of talk briefly about things to think about at each step in the process. So let's go on to the next. There's a board level. There's a project with the ABA I'm working on right now that's related to cybersecurity advice for board of directors level of organizations, for-profit, nonprofit. I don't know if the board really 50 years ago in a lot of organizations that weren't software or tech companies spend a lot of time on technology issues or privacy. It's a huge issue now. What does the board have to understand in decision making about the requirements of the organization to handle data, to process data, to transmit data? So that's from the top down. It's happening. Let's go on to the next one.
And if I could, you see a lot more that technology and data and your systems can be the impetus as well as a consideration for deals. So IT becomes much more integral to the process.
Right. A lot of the value in these transactions is either in the value of access to the data that a company has, or to their patents or their intellectual property. So what we're seeing is that cybersecurity due diligence has to start at the beginning, and it has to look, and that's why it has to look both at the processes and systems as well as where the data is flowing and how the deal is going to be. What does I mean? What I mean by that is there's one example Rich will talk about where a company was acquiring another company, and the target company had a latent, essentially a latent bug or hack, major bug in it, and when they merged them, it was the pathway for the hackers to get into the whole enterprise. And so the point of all that is a lot of people at the business level aren't really thinking about those things. So let's walk through some of the process steps. Again, this is what you're looking at: systems, infrastructure, processes. What is the rights that you have or don't have? One of the issues is a lot of these cybersecurity and data involve consent. Do you have consent from a customer or another person to use their data? And often some of that issues that are coming up is, well, you have that, can you pass that consent on to another company if it's an acquisition or a sale? Let's go on to the
We can go. Again, we keep getting back to reasonableness. And really it's a balance of risk of loss versus effort to protect against loss. It becomes facts and circumstances, and it becomes what would a prudent person do? What would a good conscientious IT person do? And so we're going to get to the mergers and acquisitions, what to look for, when to sound the alarm, and basically how to perform an audit. These are all things that the IT person should be talking with the business people and the lawyers about ahead of time before you start going into mergers and acquisitions or partnerships or transferring data. This should be codified and understood by all, how it's going to happen from a legal perspective, but also from a technical perspective, and how you audit and monitor that.
Go back to that risk assessment slide
sure.
that you had there.
Okay.
So this is in due diligence. When we're talking about due diligence, we're talking about the process of getting ready to have some type of a transaction. It could be simply buying, it could be purchasing or selling a business, it could be acquiring a piece of technology, it could be investing, it could be creating a joint venture, it could be a license of one company's software technology to another. In those deals, due diligence is simply broadly what do you look at to make sure you know enough of what the risks and the rewards are. I think this one is an interesting one in that there's an aspect of this that I find is happening more and more. I had a major client with a major deal that basically got stuck on the original software was not internet-based. And we had a large fight 8 or 9 years ago about software escrow. They then moved to a software as a system platform, and we had a large fight about 3 or 4 years ago on a standby environment. And at the end of the day, this whole business recovery and data disaster recovery and business continuity is a major driver in deals, because if I'm using your software and all my data is in your system and you have a problem, and I can't run my business, well, what are the remedies? So that's where I find as a lawyer, I'm always asking to get IT professionals to help us to understand what are we really doing? Because lawyers can have academic arguments about these, but at the end of the day, when that business stops being able to operate, it's really the people that know the systems that are integral. So I think the risk assessment is happening earlier in the assessment of deals and throughout the process.
So most of you are probably familiar with the Verizon-Yahoo acquisition. Basically, there were 2 large unreported data breaches that occurred well before the merger or the announcement of the deal. And they affected over 1 billion customers of Yahoo. The problem is it didn't come out until halfway through the deal process. And as a result, Yahoo's investors lost $350 million worth of value as soon as Verizon found out about it. And then Yahoo had to set aside almost another $100 million for claims. And then they had to assume liability against future damages, so they couldn't get their money out right away. So basically they lost a big chunk, then they had to set aside another chunk for anything that they knew was under claim, and then they had to put some of their money in escrow so they couldn't transfer out. All it could have been solved if they had just done a cybersecurity due diligence before the deal, before they announced anything. If the IT had gone through and walked through the process, they would have known this had happened, and they could have alerted management and mitigated the circumstances. And it probably wouldn't have been a big deal because Yahoo stock was probably reflected of that, of their current state. Another one is, you guys may know of the Reed Elsevier-Seisint acquisition. So Seisint has this software that they owned that police forces used. And it was really for background checks, and it was in part to their criminal databases. Once they merged, they found out that one of the sheriffs here in Florida, the department all was using the same username and password. And one of the guys was logging in from home who was also surfing the net and got a Trojan on his home computer. And he ended up, once the merger occurred, the hackers went from this sheriff's personal computer to the sheriff's station and to Reed Elsevier. And they ended up downloading over 300,000 driver's license, social security, and personal information from Reed Elsevier and the police criminal database. Reed Elsevier, and many might know that they're a big publisher of books and textbooks, and they do really institutional type information. Their stock fell by 1.3% in basically overnight, and they lost more money in the stock drop than they paid for Seisint. And you see that a lot coming up. The company ends up losing everything that they were buying, or the company that's getting acquired basically walks away with nothing.
And these last two, I think, are good examples. The first one that we had talked about, the Verizon-Yahoo, was something that happened before the announcement of the deal. So before you're going to announce you're doing something, it's becoming more common practice to have sort of a cybersecurity due diligence. This one is that the fact that you announce a potential deal can set hackers to work on the two targets.
Right.
So in each step, we're seeing new activity occurring.
And they're looking for that weakest link. TripAdvisor-Viator acquisition. Again, TripAdvisor bought Viator, which was a recommendation for software for trips and vacations. They paid $200 million for them. 2 months after the deal, they're informed by their credit card processor that for the last 6 or 7 months, hackers been into the Viator database and stealing credit card information from all of Viator's customers. So they had 880,000 credit cards and personal information stolen. Another 500,000 were compromised.
This was a breach during the deal, not
Right.
prior to
Right.
announcement.
Right.
After announcement, this was during the process.
This is ongoing from the minute they started the courtship through closure, and they just never noticed, they never looked. And they ended up, TripAdvisor lost 4% of market share, which was $580 million, so almost over double, almost triple the value that they paid for Viator, and they had to spend $350 million to remediate the damages, including pay people that had their information stolen.
One of the reasons I think these things were occurring, I think, and were a wake-up is in most of these types of transactions, there's traditional checklists. Some of you may have been involved with somebody sending you a checklist saying, we need to know about all of the IT systems, all of the licenses, we need to know various information about technology and data. Those checklists didn't typically have a place for cybersecurity, and they certainly 5 to 10 years ago weren't thinking about the announcement of a deal being the impetus for a hack, or that before a deal you needed to do it. So this area is coming quickly, and I think it's a centrally important role that IT professionals can help their businesses, whether it's suggesting this or working through this, because again, the professionals that do deals, this wasn't in their mind 10 years ago, 5 years ago, probably even 3 years ago. So you may get requested to help with a checklist for kind of if your company is acquiring a lot of people, or if your company is doing a lot of licensing type deals, you may get asked to help with a checklist for what are the cybersecurity things that we should look at all these stages. That's why we wanted to point this out, because it's a new world that hasn't been typically involved.
And the last one I think Tom was mentioning, this was 2 hospitals merged in Philadelphia. Tom's hometown. And so there was basically a server in an office that wasn't used all that much, so it was shut off and never got the updates, and it had a Trojan on it. And when the merger occurred, they turned everything on, and this computer and server became connected to the network. And all of a sudden now somebody's getting information, and they started hacking, and they got access to 300,000 patient records. And they held the hospitals ransom. And it was the second largest healthcare ransomware-related issue. They basically said, if you want your records back, you're going to have to pay us. And so imagine, two hospitals merging and get all this great publicity, and it was shot within a week.
I'm going to walk through quickly a few different things about where data is involved now in some of these transactions. And in the interest of time, I'm going to go fairly quickly, and then we're going to stop in a little while for questions. So if you have a question in one of these areas, please write it, submit it, or give it to us. But contracts, this looks very simple, I would imagine, if you've been involved in any kind of a contract, whether it's a software license or a supply agreement or a sales or distribution, right? But I find now what we're having to ask is a new set of questions about data and IT systems or technology systems in areas like grant of rights has always been one in the software world where it was always the question of, well, did you get the rights you really need? And was it, 20 years ago, was it a site license? Was it a user license? That continues. Those questions just change as the technology change, but are always important. I try to think about or tell both younger lawyers and clients, really you need to ask for these kinds of licenses and contracts, you need to answer the who, what, when, where, how, and why questions. And it amazes me how often that sophisticated deals, somebody's forgotten to answer one of those questions. Who gets to do what with it, when, where, how, and why? Simple questions. So some of the things that come out are with data, who can use the data, what do we have to pay, are there territories or exclusions, terms, and then the legal issues, the things that I think lawyers get in a lot more, indemnification, warranties, limitation of liability. So the point of this simply is these were always questions around, like if you were dealing with software, these were asking. Now we're asking, we're looking at the data and the data flow and the cybersecurity with these types of issues. Let's go on to the next one. So with licensing, these are just some different issues. What type of license? What are the terms? Again, I like to help make it simple, the who, what, when, where, how, and why, but cybersecurity and data is a new question in licensing of your technology. Next slide. The grant specifies, again, who has what rights. Let's go on to the next one. And then I think one of the ends, these are always important questions. What's the extent of what I can do? And if you just think of data issues or cybersecurity, right? What is the geography that this is governing? And when you talk about cybersecurity, well, that's sort of everywhere, right? So the whole territory, I find agreements where people talk about a territory where they're really thinking about, I am going to let you resell my product here, but the territorial scope is the whole world, right? And so with cybersecurity, we're thinking about what's both the extent of what's being used, but where could the breach come from? What if it comes from, I was just recently in Botswana. I had never been there before in Africa, and I read an article that Botswana is, while it's one of the safer countries in the world, it has one of the higher, apparently, cyber hacking centers. Who would have thought? And so I was very careful at this hotel about, I thought twice, do I want to hook my laptop up to the Wi-Fi or not if I'm apparently in the capital, one of the capitals of African hacking? I have no idea if the article is true, but it caught my attention because otherwise it was a lovely place that seemed very safe. The term, how long can you do it, and then how does it end? I find, and these are issues that look very rudimentary for contracts, but I'm finding that there's a lot of argument occurring on data. Like when does your rights to the data end? If the contract terminates and it's a cloud-based contract, and you're the cloud provider. How do I know whether I get my data back? What form do I get it in? Is it useful? Those are questions that many lawyers don't really understand, but they're essential, right? Yes, we'll give you our data back, but we'll give it to you in a way that's so unusable. So that's, again, these are all areas where I think IT professionals are more and more essential in that basic business function.
And the other thing is, some of this now goes to the consumer. What kind of agreement or what kind of deal did you strike with the consumer? Do they expect or know that you're doing these things? And again, you start to look at different countries and different industries, and what you have to get from them changes dramatically.
So let's go on to the last topic. We have about 5 minutes. Is this whole cybersecurity reasonable? One of the questions that we get asked, I get asked as an attorney in the space, is, well, what do I need to do? How good is good? And it's a very difficult question, because if I said if I asked you as professionals, what is adequate security today for a network? I probably get a lot of answers. Well, what was adequate security 2 years ago? Like what technology? 5 years ago, right? I just was, again, visiting my mom, who's not as technologically savvy as I am, and they, I bought her one of those basic electronic photo frame that's electronic, and I got the one that had a Wi-Fi connection because I could email her pictures. Well, I went to set it up, and her router was so old it was a WEP and wouldn't talk to it, right? So I called Verizon, and they're like, well, no, that one won't work very well. But she had a router that apparently she had gotten 2 years ago. I called Verizon, like, oh, that's the state of art. Well, it was in the box. Right, so the solution was there, but something as simple as a picture frame with 10-year-old router wasn't going to talk to it, but the new one was going to work. My point of all that is this is a moving target on what is good enough. Rich is going to talk a little bit about reasonableness as a standard. I think there's always you want to make sure you're doing as well as everyone, but what does that mean? Right, you don't want to be, it's kind of like my yard, right? When I took care of my own yard, I just wanted not to be the yard that everyone in the neighborhood talked about. And then I found out in Florida, which, as those of us know, you do your yard a lot of the year. I got a yard service for the first time in my life when my kids went to college. And I realized, oh, this is how everybody's yard looks so nice. So now I'm not the don't talk about me, I'm right in the middle, right? I think there's a parallel with that, with what is adequate in this whole world. But why don't you talk a little bit about the reasonableness?
Yeah, and this is sort of what supports the premise that IT has to be in the boardroom. You have to develop an organizational cybersecurity map and risk assessment, and it's got to be a living document that works and grows and changes with your business needs and your business objectives. So you've got to look at the type and means of data that you're collecting, where you're storing it, and how you're accessing it, and who has access to it. Most cases, you need to have some sort of employee access guide so that you can say who has access based on their role and what they need. And one of the case studies we saw was that someone at a bank was downloading all these files that they shouldn't have access. They used to do like 20 records a week. They were doing 200 or 300 a day. That should have flagged somebody, and they were selling their bank credit records, they thought, to a legitimate partner of the bank. Turned out to be a hacker. So, again, if someone has access to something they shouldn't, you need to know that. And as their role changes, their security protocols have to change. And then legal assessment of the policies. You have to go through and you have to sit down, and IT has to sit down with legal and say, this is what we're doing. Does this make sense? And let them ask you the questions. Well, do you have a license for that? Do you have permission for that? Are you complying with this standard? Or, how are we addressing these issues? And you document it. And that's the whole key to this, is you have to have thought it through and documented it and say, okay, this is what we did, and this is the decision we made and why we made that. And then say, we're going to update that or revisit this periodically. Some cases it might be every quarter, some cases once a year is enough. But that's where you're going to have to come back and tell the boardroom how often you need to update it. If it's changing rapidly, they need to know, and you need to be part of that, and they have to budget for it, and it's got to be part of the business plan. So, ultimately, a company wants to be able to use their technology the way, or their data the way they're expecting to make money. And at some point, they may want to pass that on to another entity, or somebody acquires them. If they don't have rights to that data and they're not using it correctly, that could be as bad as the Yahoo deal, because they'll go back and they'll crash the whole company and the entire assets. Again, common sense. You got to look at it and say, here's where we're getting our information from. Here's the standards we use. Here's how often we check. We have services that we subscribe to keep us up to date. And then, we're doing regular tests, whatever that means for your industry. Again, it depends on how much the hackers are hacking and trying. Whether you get dark web penetration tests, hire a company to try to hack your system periodically. And then, how do you get cyber awareness notifications? That's everything from a new virus coming down the pipe, or a new phishing scam that's hitting, or some new technology, or internally you're seeing an uptick in certain activity that shouldn't be there. Maybe you don't have an Australian location. All of a sudden you're seeing all this data flowing to Australia. Your system should be able to tell you that. And for a lot of people you can, but you just need to go through that in every single aspect of it. I'm giving you guys, for what you guys is obvious examples, but you need to help legal understand all the different issues and how that information and hackers are hacking.
So before we get to questions, I was just going to maybe wrap it up with, we've talked a little bit about the regulation, and again, in the U.S., we're sort of a patchwork quilt, industry by industry, protecting consumers. Many parts of the rest of the world are more comprehensive and are looking at privacy. Our premise, I hope you got, was that the IT professional is becoming more essential to all types of commercial deals, and really needs to either be brought in, which is sometimes the fault of legal and the business folks, or involve themselves, because many of these issues and risks are related now to both the cybersecurity, the flow of data, and the technology. And then as we kind of come down the road, I think this is an area that just is going very quickly. I mentioned the ABA Cyber Law Committee. About 5 or 6 years ago, a lot of the discussion was on cybersecurity insurance. And I remember they brought in a leading expert that was talking about how difficult it was to basically have a price or a market. How do you do this? And then I think about 2 years ago, I was driving down the road, and on ESPN radio, which I think I must be one of the demographics, it came on an ad for cybersecurity insurance for small businesses, right? And so in 3 or 4 years, we went from experts saying there's no way we know how to price this industry to there being insurance for individuals. So I share that. The area that I see negotiating, I think one of our questions, I think was about something to do with breach, but I'll let you ask the question. That's getting negotiated an awful lot now in all kinds of contracts and deals. Whose responsibility is it? What's the remedy? How do we do it? And I'll say, quite frankly, there aren't a lot of good answers in that area. It's just a lot of time is being spent because people know it's a problem, but they don't necessarily know how to fix it. So let's open it up for questions.
First off, great presentation. Thank you guys so much. I know your ideas that you've shared have even just sparked so many more questions than I have now.
Thank you.
Thank you.
Yes, and Tom, you were correct. We already have questions rolling in. The first one is, if a breach has happened, what should we do? Like, who should we contact first?
So my thought with that, and this is going to sound like a lawyer answering the question, but I hope that you don't have a breach, and if you have it, I hope you've thought about that before, right? And I think there is a role, there's certainly a role for the key IT folks in your organization, and I hope that there's some plan before, but there is a need to get a lawyer involved because there are certain protections for investigations. You need to know what your state, like for example, Florida, we have a law on notifications of breach. So you need to know what your requirements are either under your state or under your industry. So you're going to need your IT person, your lawyer. Many folks are going to have some sort of, for lack of a better word, a PR aspect of it. and key leadership. And so I don't know which one you call first, but you want to have all those people at the table.
As long as you have a plan, right?
Yes. Well, and those are people, yeah.
All right, we have another question that came in. Is it worth prosecuting when most attackers are outside of the United States?
So I don't know what prosecuting means, a lot of different things, meaning one, prosecuting is criminal, right? Prosecutors, we think of prosecutors are people who enforce criminal laws. That can be very difficult internationally. There's also, we use prosecuting and legal in different ways, meaning you may have remedies to stop it in the courts. You may have money remedies that may be different than the criminal. And all of those are difficult if it's international. It's at least looking at what are your remedies.
Okay, great. Now I'm going to go ahead and open the floor up for any questions that we may have here. Do you guys have any ladies, anything they might want to ask? All right.
I work with computers all the time. I'm actually a person that has read the license agreement before you press F8. Now, how on earth can you secure anything that has no guarantee for performance or work? I'm just saying, I'm sure you've read those F8 unless they've changed, since like Windows 7, because I haven't really read it since Windows 7, and then like when you install a Cisco router, you have to press F8. If you ever read what F8 says, they say they're totally off the hook. I'm totally flabbergasted that they have handed the whole healthcare system of the United States over to companies that do not guarantee anything they do for any purpose.
I think historically, that's a good point. And
so it's like, how can you secure something that doesn't even have a guarantee that it'll work or even do what it's advertised?
Well, I think that's a broader question about the IT profession, the IT industry. So if you think of the car industry, or any industry. Well, but if you think as the car as an example, right? There's certain warranties that when you buy a car, you expect it to run. We have some legislation about lemons. We have some rules. Interestingly, historically, some of the leaders in the software and computer industry, I won't name names, you could probably guess if I said they had 3 initials and have been around a long time, started contracts where they disclaimed warranties, they disclaimed performance. So much of the software world has grown up with that as the industry standard. So I don't think that totally lets everyone off the hook. There's questions of, a lot of those are about how will this function? I'm not going to guarantee that my math in my software is going to add right, or that I'm not going to have errors. It's a little bit, obviously you all know better than me, it's harder than maybe an engine running. But so those agreements, both whether it's on the individual user or the organizational level, do have a practice in this industry of disclaiming many warranties. However, when we get to cybersecurity, there's a lot more emphasis on was a party negligent, regardless of the contract. Did they act well? Were they negligent? Was it intentional? So you don't get a free pass in the law by having a contract that says I don't have any responsibility if you're negligent or if you're grossly negligent or intentional. So it's a good question. I think on the individual licenses, they're different. I write both. I represent users and software companies. On the individual user license, what we would call click-throughs, that's a little more standardized than big institution-to-institutional operational. And I will tell you, people are negotiating a lot about liability for cybersecurity, even though there are disclaimers of warranties. So it's a very good point. But that's what the industry is. You don't get software that works like you have protections that your car is at least supposed to run for a little while.
But there's also different standards for you, like an individual when you buy it versus when there's, affects a large group of people, right? Because the government will step in and enforce different standards. So where you can have an agreement with the software company, I'm not sure that would cover the breaches or things like that to the same extent. You know what I mean? Because if the FTC comes down, they're not going to say, well, yeah, your warranty doesn't apply here.
I noticed that Russia has a new law says that all personal information's got to be held inside Russia. So LinkedIn has been kicked out of Russia. And they say, well, Facebook hasn't been attacked yet. But are there other countries that have these laws that the data has to reside inside the country?
Well, there's different countries have different sets of data-related laws. So most of the countries have European type or similar, meaning they're protecting how people use it. I will say, to answer your question, the EU, their 1990s data directive was no different in that they did not allow data to be transferred to a country that offered less than adequate protection, which was the United States. So if you remember, there was a safe harbor negotiated under the Clinton administration to solve that. So there is a history of saying, if you don't protect our data, we don't want it outside of our borders. The Russian may have a different impetus than the European, but yes, there are some countries, many of the countries are trying to protect their citizens on where you can flow the data. That Russian is a new flavor.
Who decides what the reasonableness is? In the beginning in the morning, who do you have to answer to? I mean,
I think I think that's a very good question. I think you've got the regulated activities. For example, those first sets of laws that we put up that we tried to go quickly through so you would stay interested, right? But like the financial industry has a group of legislation. We all know the word HIPPA, although we maybe don't know what it means, but the healthcare has it. So in the U.S., you have to follow those regulations and act according to that. And then there are other principles in legal, but that at a default, the reasonableness is if there isn't some other regulation or other specific statute, the courts have basically been trying to figure out how do you decide if someone acted well. So reasonableness is a legal issue that's probably a cousin of prudent, meaning something that everybody, if you're keeping up, like I told you about my yard, right? If you're at least doing what the industry does, that's usually reasonable versus having to be the best. And it's often areas where we don't have a statute, we don't know how to define it.
Richard and Tom, thank you very much again for the presentation. I've enjoyed it. I have a question. I'm a small business owner, not a real small business, but fairly small, but we're involved in a lot of the areas that you have covered tonight: healthcare, payments, hospitality, other areas where we sell not only our own products that are involved in dealing with a lot of customer data, but also third parties. And so we're resellers. And so my question, I guess, is how much liability do you see for a company, and what can I do to mitigate that other than the points you've already made? I guess I'm asking, should I get cyber insurance? Should I retain an attorney for just general consultation? And where can I get legal information that's up to date so I can review and make sure my processes are being done correctly?
There's a couple. I'll maybe start backwards with your last one about where would there be some helpful information. Well, some of these governmental organizations that we mentioned, for example, the FTC has very helpful things on its site. So some of those groups that are the government or others that are regulating the industry that you're in probably will have some helpful information. Should you retain an attorney, I would advise you, at least in your situation of selling and reselling, at least having a relationship where you can kind of look at, we were just recently helping a company that does web development, and they were asking about privacy issues. And so some of it is, well, what industries are you selling into? Maybe stopping and at least looking at your contracts to see how you're protecting what you're offering. Like your question in the back, what are your requirements in your contract? What indemnity obligations may you have? That's where I mentioned there was a slide that had limitation of liability, indemnity, and warranties. Those are kind of three things that are helpful to get your head around that a lawyer may be more helpful than the business terms, right? You may understand what margin you got to sell at to stay alive. And then the reselling is an interesting issue because it really, I think, comes into, are you just passing on someone's software, or have you brought in 3 or 4 companies software into a combined solution. And if you're the front of the combined solution, you probably want to think a little bit more about how to protect yourself. And I think there's contractual protection and insurance are always worth looking. Some areas, the insurance is cost prohibitive for some size businesses. But the idea is that if you're the tip of the spear and you're bringing in 3 or 4 other companies and something happens, your large user client's probably going to point the finger to you and let you sort it out with the others.
I have a short question here. What is the legal jurisdiction if you connect your server to the internet to sell candy or trinkets? Once you connect, are you exposed to worldwide litigation?
It depends on where you are and what their law is. And when the internet started in the 90s, a lot of the cases were about that question. Where is the jurisdiction? Because it was all new. I think it's settled down. Different countries have different rules. I think in the U.S. we look at kind of what there's a constitutional case and standard that looks at a concept called minimum contacts. And there's certain factors, and the idea is, are you really having a contact in that jurisdiction? And so for some areas, a website going in is enough. For other areas, a website isn't enough. You have to sort of actively solicit. So the answer to your question is that area is fairly well now mature, but it does differ based on the activity you're doing and the jurisdiction you're dealing with. And there's not a faster answer than you have to look at that.
And it's really interesting because we see the evolution. I don't know if you guys have heard about seasteading. This past week, some heavy players in the Bitcoining, they tried to homestead outside of territorial water, so they were exempt from these types of regulations. So I can only imagine this landscape even changing more. So that's why we have people like you to help guide us through this process. And thank you so much again for presenting tonight. I'm sure everyone here, as well as our live audience.
Thank you. It's our privilege.
I do have just an announcement real quick before we go. I'd like to let everyone know that Dr. E. Ted Prince of the Perth Leadership Institute will be conducting our next presentation, and that topic will be, Am I an Innovator? And so that's going to be a really great one to look out for. Remember, you're always welcome to come here at the IT Pro TV studios in Gainesville, Florida. If you can make it live, we love that. But if not, then you can check us out on Facebook, and we'll stream it there, as well as uploading to our YouTube site for, later viewing at your own leisure. And I just want to thank everyone so much here live and for you out there in your homes for joining us tonight. Thank you.
Thank you very much.